get a recording. All right. So again, thank you guys for coming. Leslie introduced some of the folks on the team. Lynn is our client service specialist in the back, so she would be answering the phones for us. Somehow I picture in my mind, I look a lot better looking until I actually look at a picture of myself. And then the one gentleman we have there, Ken Smith, isn't able to be with us. And then we have Forrest Miles that's just joining us down in the Haymarket area. So that's the rest of our BCT investment team. So we've got to go all the way back to the very beginning. I know you guys were all looking at our famous people on here. Of course, we probably all know Mr. Tony Soprano on there, but you may not know the other individual. So, if we think about, what is it that we want to say? And so tonight's we're talking about estate planning. And so sometimes that can be maybe a little bit fancier word than most of us may need. But really, what is it that we would want to say to our loved ones if it was the last thing that we had an opportunity to say to them? So this is Randy Posh. So Randy, unfortunately, was diagnosed with pancreatic cancer at age 45. So, and unfortunately passed away at age 47. So what is it that we would want to impart to our loved ones if it was the last thing that we had to say? He, I think, did a fabulous job in kind of setting up the last couple of years of his life, became a very famous lecturer and became known for that last lecture on YouTube. You guys ought to look it up. It's pretty heartwarming. So some of his quotes from some of his last lecture that he had. So let me read a couple of those quotes that he has. So the key question to keep asking is, are you spending your time on the right things? Because time is all you have. And, be prepared. Luck is truly where preparation meets opportunity. And kind of his last one, to be cliche, death is a part of life. It's going to happen to all of us. I have the blessing of getting to know a little bit of advance notice and was able to kind of optimize his time. So like I said, it's pretty cool. He's got a book out, some stuff out there on YouTube that you guys can look up and just spend a little bit of time getting to know Randy. So how was Randy different than Mr. James Gandolfini? Well, so two contrasts. Of course, he's best known for his HBO series, but died unexpectedly at 51. So unfortunately, he did not have a will. And there are some, so the fancy term is intestate, which means if I die without a will. And so as Alison can attest to, do we know off the top of our head some of the intestate laws here?
Sure. In West Virginia, if you die intestate, your heirs will receive your property, but there can be some adverse tax consequences to that. And just because they're your heirs, it may not be in the proportions in which you would have chosen for yourself. So if in West Virginia, there is a statute called intestate succession, which lays out which of your heirs get what and how they get it. And we all have different familial situations and circumstances. And sometimes it's not what you would have chosen to do had you had the opportunity or taken the opportunity to draft estate plan documents for yourself. Can also be very complicated if you have minor children, because minor children cannot inherit until they've reached the age of 18. And so who's going to manage that money for them? How is that going to be held for them until they reach the age of 18? It can become very complicated. And you have to go through the full probate process, which can also be time consuming and expensive.
So believe it or not, you all have a will, whether you think you have one. It's just whether the state in which you live has outlined where stuff is going to go. So, it's best to have that stuff drawn up ahead of time. And so in Mr. Galdolfini's case, only 20% of his estate went to his wife. So I'm not really sure if that's what he wanted, but leaving 20% to your wife's probably not a good thing. And then the tax implication for his estate was probably astronomical and significantly more than probably what it had to be. So this is just kind of a dramatic. So I think the way that, believe it or not, I've never watched The Sopranos, but I guess the last episode just goes to black and that's it, right? It's over. So unfortunately, that's maybe that was Mr. Galdolfini's case. So as we said, we're going to be talking about estate planning. We tried to come up with maybe a little better verbiage for that, but it's kind of, usually people when they hear estate planning kind of know what that entails. But we're going to kind of dive into it a little more. We have to put our disclosures. Unfortunately, I feel like in the investment world as well as the loan world, our disclosures seem to be getting much longer than anything else that's out there. So they take up about a half of a page. We've got a little survey there. We would highly appreciate you guys filling that out. If not, wait for it to come via email. And of course, we'd love you to check out our website. And there's more information out there for you as well. We are very educationally minded. We love planning. We love helping to educate our clients. We have a college planning coming up, talking about investments in that arena. We're doing a Social Security one. And then later on in the year, we'll do Medicare and long-term care. So be on the lookout for those. So statistically, only 55% of adults don't have wills. And so, a lot of our clients, again, that's 1 out of every 2 people we see. And I would say that tracks pretty well with kind of, what the statistics are saying. And, so our first encouragement always is segregate some dollars, get out there, get it done. We would highly encourage you to do that. And I think it's just unfortunately one of those things that we just don't want to take the time to do. But so important in what we're doing. So as you can imagine, passing away, we're leaving no official guidance to our family. It can create conflicts within the family. Where dollars are going or how they're going to be passed. As Alison mentioned, stuff may go places you don't even want it to go. And then probate, of course, is divided by kind of the state laws. So, one of the things, obviously, that really hurts is, the family really has no direction. As you can imagine, they don't really know kind of where dollars are supposed to go or even where things are supposed to go. So incapacity. And so one of the first things we need to think about, a lot of us think of estate planning is what happens when I pass. But in some cases, it's also making sure that incapacity is also taken care of. So, a lot of us, stroke sometimes, or maybe a severe accident, which you may be in the hospital for an extended period of time. So have you decided who's going to be able to make those decisions for you? So, I think there's usually we tell clients is that there's probably the financial side of your life, and then maybe there's another part of your life of who would care for you. So, the financial side and the caring side may be 2 different people. So, you might have a part of your family where they're more numbers oriented, and then someone that's, maybe is a nurse or something like that. And so separating those 2 things is something that you can do. And we were just talking with a client last week, and they were like, no, I didn't even know I could do that. I thought it was just had to be one person. So is there anything you would suggest around that, Alison?
So we always consider having 2 people, not serving jointly, but having your primary person and then your secondary person, because if your primary person is your spouse, for example, which happens 99% of the time if you have a spouse, and you're in a common car accident, then that does no good. So you need to have a backup person for that primary person as well. And you need to think about also, in our documents at least, we also basically present to the court via the document who you want to be your guardian if you need one. So it could be that, you have a daughter or a son, but really you don't have a great relationship with them. And if you had your say so, it might be your niece that would be your guardian. This document is your opportunity to say that out loud. Because otherwise it's going to likely go to the next of kin. The court will make that decision. You don't get to make that decision. So it's your opportunity to kind of say, if I'm in this situation, here's who I want to take care of me.
Thank you. So a lot of us say, I don't know if this is the primary obstacle, but, thinking of yourself passing away, I don't think is ever easy. And probably one of the, it's a very, I'll say easy again, but so it's an easy thing to kind of put on the back burner. And so it just kind of seems here in the last 4 or 5 years, I've had some very, very good friends pass away. And, having, kind of hearing and listening to their different stories really helped me to kind of give me the, whatever you want to call it, but really helping our clients to really think about that and putting a little bit of pressure on them to really get in and think about that. So one of the things we started doing is putting together like a checklist and even a binder. So when my dad passed, we were able to, and thankfully he had taken some time to be able to do that. He had put everything in a binder to where he could just go in and pull that right off of the shelf. Everything was in here that we needed access to. So, staying organized is really important. Getting those things done, of course, is of utmost importance. So any suggestion on storing documents, Allison? And
Sure. So we typically suggest to our clients that they keep them in a fireproof, waterproof location. That can be a safe in your house. It can be a safe deposit box at the bank. I actually have a client who keeps his documents in the freezer. That's his choice. But your next of kin or the person who you've named as your executor or, the person who's going to handle your affairs for you needs to know where those documents are because most people are not going to look in the freezer for those. There's also sometimes concern with putting things in a safe deposit box that without a letter of administration, you can't, and you're not on the safe deposit box, you can't get into the safe deposit box. But there's a mechanism for that. Most banks, and I can't speak for BCT, but most banks will go into the safe deposit box, get the estate planning documents out. Then when the person gets qualified, they bring the letter of administration back, and then they have access to everything in the safe deposit box. So don't let that, steer you away from using a safe deposit box.
I will also offer that BCT Wealth, we do offer storage we have a vault in the back with a fire. Within the vault is also a dual control, fireproof, waterproof filing cabinet. So we keep our clients' wills in there. We do not open them. And we do check the obituaries every day. And if we see the name in there, we simply walk the document across the street to the courthouse. Again, we don't open it, but it goes straight to the courthouse. And that's a good way of making sure that it doesn't get lost. Or sometimes we've heard stories that maybe family members have found the original and misplaced it.
That happens rather often.
Yes.
And I would say make this, make your organizational skills appropriate for yourself. So I forget, it was like 15 years ago, big kick. I was going to get very organized, get everything in order, and went out, took my safe deposit box. That's what I was thinking back then. And then 5 years later, can I tell you where my safe deposit box key is? No. So, all of a sudden, so I would say make your organizational skills, work for you. So, I'm saying a binder, maybe it's the filing cabinet, maybe it's the safe at home. But also we have one of our clients that writes a letter to his wife every year and to his family. So around Christmas time, that's what he does, writes it all out where everything is. talks to his family. These are the key folks. And that's part of their Christmas present is that little letter from a husband, grandfather, wife. Of course, there's lots of obstacles. We've kind of been beating this a little bit here, but probate, creditors, lawsuits, judgments. So those sometimes are all things that can impact the legacy without proper planning. So guardianship is an important one, I would say. It seems like a lot of us, we get married and we're going through life and all of a sudden we're going to have a child, right? So that kind of brings something into the equation. So we see a lot of folks beginning to think about it then, but especially if you have, minors or loved ones that may need additional care. So those are all things that definitely bring problems in. So, one of the big things is the healthcare wishes. I think a lot of us, that old term of, well, pull the plug on me if I'm not doing well. So I think there's some things there to definitely kind of think through. Possessions, where things are supposed to go. So avoids additional unplanned legal expenses, having to get special documents or things, or even time frames can sometimes be extended. So all things, of course, that are avoided with some proper planning. And I was going to ask Alison, like, is there talking about heirlooms and things like that? Is there? That's a common kind of a thing, but how would you suggest folks kind of deal with, maybe the table's supposed to go to my oldest daughter because that was my wife's, favorite place, or, rings, and how do you account for that?
So we have two ways that we deal with it in our documents that we draft. One of them is that we will hardwire it in. So if you're 100% certain that you want your engagement ring to go to your daughter, or grandma's rocking chair needs to stay in the family and it's going to go to my nephew over here, we will hardwire that into your document and it'll be part of your document. The other option that we have is that we will include a personal property memorandum. And so your document will say, with this document, there may be a personal property memorandum where I may direct my trustee or my executor to distribute this personal property in the way set forth in that document. It's basically a couple of sheets of paper with some lines that say, here's the item, here's the description of the item, and here's who it goes to. And that is the direction to your executor or trustee to make that distribution as you have it there. That's really helpful because, you come into the lawyer's office to get your estate planning done and you're thinking about the big picture items. But then when you go home, you're like, oh, I do have grandma's quilt and I really want to make sure that goes to so-and-so. Well, rather than coming back in to me to have me redraft the documents and the expense of that, you'll have this form that you can fill out and you can change your minds. I mean, the other benefit of it is it's pretty flexible. So, you may say in 5 years, my grandchild would really like to have that versus my child, and you can change it yourself. You don't have to come into our office to make that change.
What did you call that?
It's a personal property memorandum.
Yeah, so for those of you guys online, hopefully you heard that, but personal property memorandum. And so one of the things I've heard is that if you have it hardwired in the will, does that require like an appraisal? And so that's
not in West Virginia. I can't speak to other states, but in West Virginia, it does not. Sometimes you'll have personal property that's appraised only for the value of it to report it for probate, but it doesn't matter as far as to whom it gets distributed.
Okay. I thought I had heard that at one point that was, but again, it could have been
collections. And as part of the probate process, you have to value certain items over a certain amount of money. And if a collection or a tangible item is going to be over that threshold amount, it may require an appraisal. It's very rare, but sometimes it happens.
Yeah. So the other aspect sometimes, we talk about documents and we think of wills and trusts and those kind of things that are the actual physical items. But sometimes, is there anything intangible, that we would like to impart and ways to do that? So I know some of our clients have done actual videos, of themselves talking about their family, things maybe that their grandfather or great grandfather has done, even down to visiting grave sites and that kind of thing, of documenting some things like that. And, with the ease of technology anymore, taking your cell phone out and doing something like that. So sometimes I think that may be a part of even the estate planning that we might miss is there something that you're proud of that you would like to impart to family or, grandchildren, great grandchildren. And so it's, sometimes I think of that in two phases. So we want the actual physical documents, but then maybe is there some intangible things that we might want to pass down. So that's kind of the two different objectives that we were that's here on this slide is the actual physical and then maybe the intangible things that so of course a goal in successful legacy planning is of course we want to make sure our spouse is taken care of and is able to live comfortably and knows where things are. And really that can go both ways. So I've seen some couples where the spouse does all the bill pay and everything, and or the wife does that, the husband does not, or vice versa. And so, making sure that, wherever you're at, that both parties are going to be left prepared. Children, the legacy planning. So, meeting with our clients, a lot of times we're now asking, and on our forms, it's even started asking for another designated party that you would trust to be able to ask on your behalf. But kids, talking to them about taxes and the implications of that. And then, of course, as hopefully as you build your generational wealth, that passes down to even grandchildren and being able to pass that down all the way down. And philanthropy. So what is it that you would like? Is there any impact that you would like to have, on your local community here? Maybe there's some dollars you would like to leave other places. So, even possibly enjoying that even, while you're living. So we don't dive a lot into the estate taxes, but gifting is definitely a good thing, even at the levels. So we can pass Alison right now in estate tax free, and
West Virginia follows the federal limits, so it's over 11 million right now. For married couples, it's 23 million. So there's no gift tax or anything until you reach that limit.
And the annual gift tax exclusion
Is 17,000 in 2023. So you don't have to, it doesn't mean you're going to get taxed on the amount that you give. It just means you have to report it, anything over 17,000 per year to any one individual. You have to report to the IRS in the gift tax return. Some people think when they hear gift tax return, they think they have to pay tax. You don't have to pay it. You just have to report that you gave a gift.
so it's hopefully I'm saying this but properly, but so you've got an $11 million bucket that if you go over that threshold, that is essentially reducing the amount that you can eventually pass on. So needless to say, $23 million is a very big bucket that unfortunately maybe most of us don't have to worry about. But either case, 23 million is a lot to be able to leave without having to pay that inheritance tax on it. So we've outlined kind of 6 steps here in kind of our in our legacy planning. So the first one we kind of covered is, plan for that incapacity. So heaven forbid, last year I had a client go through this, had a massive heart attack, was in the hospital for months, actually had a heart transplant. So 3,000 people in the United States have heart transplants. And this gentleman was one and had no more family, and thankfully had entrusted his next door neighbor to be, his executor and advance directives and power of attorney and all that kind of stuff. And so thankfully he had a neighbor willing to be able to go through those things. So the advance directive is a healthcare. Do we sometimes call that a healthcare power of attorney as well?
Yeah, in West Virginia, we commonly refer to it as a medical power of attorney. The medical powers of attorney that we draft in our office include a living will. which some attorneys opt to draft as a separate document. It can be, I mean, it's just a preference. We include it just because it's easier to take care of one document than two. And the living will portion of that document is the one where you get to make choices about your end of life decisions. If you want to be kept alive artificially or not. And you get to make that decision in the document versus putting that burden on a family member.
Is that similar to the 5 wishes?
So
document?
I hate the 5 wishes document. But there are people who love it. So the 5 wishes document is not a statutorily approved document. Our powers of attorney in West Virginia, both financial and medical, have been approved by the legislature, which means that if I hand it to you and it substantially looks like the statutory form, the banks or the medical professionals must accept it. The 5 wishes is kind of someone came up with this form and they said, oh, it's lovely, and people get to write what they want. No one has to accept that document. So you may have filled out the 5 wishes document, but you're now incapacitated and you're in the hospital and the doctor's like, this is not the statutory form. I'm not going to take it. So we can take your 5 wishes that you want and put it in the statutory form so that no one can say like, I'm not following
Do
that.
some states take that?
I don't know.
We didn't have to. With my Maryland and Pennsylvania, my parents and in-laws both have them.
Well, yeah, and sometimes
But we
medical
didn't have
professionals
to-
will
we
take
didn't have to
them,
pull on-
but
we
they
didn't
don't have to take them. So it gets a little dicey at times.
So you would just translate that into the statutory form.
Yeah.
Yeah. So for those of you folks online, I think we had a question on, so what about 5 wishes?
Mhm.
And I think, I think the volume's probably coming through good enough for everyone. But so I think as in anything, there is the 100% legal explanation. And then there are things that sometimes may be in a little bit of a gray area, and that may cause complications. So I think it's a decision and hopefully I'm saying this okay, Allison, that it's a decision all of us have to go through, right? Of whether that's kind of the venue I want to follow. And then I think, but you may be putting the doctors in maybe a little bit of an awkward position, but so the legal and then maybe following a little bit in the gray area of that. So anyway, so advanced directives is so we talked about the 2 things: power of attorney and for finances. And so some folks, so Allison, do you want to talk to the power of attorney? Maybe the different levels that you can have, and maybe I'm saying that correctly, but financial
Sure.
or medical, or just a power of attorney can be very broad or it can be very narrow.
Right. Typically, when we talk about powers of attorney, we talk about a financial power of attorney and a medical power of attorney. And you're basically designating an agent to act on your behalf. So with the financial or statutory power of attorney that we talk about, it's only with regard to your financial life. That person is not making medical decisions for you, except as it may relate to your medical care and paying for that medical care. But they're not saying, yes, let's have the appendectomy or, whatever that medical decision might be. That person should be someone who's conscientious and good with money. It should be someone that you entrust implicitly, because when you give that power, they truly have power over your entire financial life. So if there's 1 ounce of maybe this is not the person to do that for me, then you should follow your gut and pick someone else. Unfortunately, I've seen that happen too many times. And that's one of those documents where you need to have 2. You need to have your primary and then your secondary. The medical power of attorney, you're designating an agent to make medical decisions for you if you're not able to make those decisions for yourself. And these are decisions, whether you are incapacitated because of Alzheimer's or dementia, or you're in surgery and the doctor gets in there and says, hey, we got in there and we found this. Can we go ahead and take that out too? Well, someone has to make that decision. And so that person would be the person to make that decision for you.
Okay. Yes.
The financial power of attorney, they have the right to make any financial decisions for you. What if, do you have to be incapacitated for that to become effective, or can they do it anytime?
That's a good question. So there are kind of within the power of attorney two types. There is one that's effective immediately, and there's the springing power of attorney. And the decision of whether you make it springing, where basically something has to happen in order for that power to spring, to become effective. That's really a case by case basis. If you're a married couple and you share everything financially anyway, I wouldn't do the springing. I would just do it where that person has the power immediately. If you're a single person and you've chosen maybe your neighbor or something because you don't have anyone else, then maybe in that situation, the springing makes more sense. The problem with the springing is that there's typically there has to be some action that has to happen. And typically it's 2 doctors sign off to say that you are incapacitated and can't make decisions for yourself. The problem with that is getting those 2 doctors to sign off, because that's 2 examinations that you have to schedule. That's, and that can take weeks. In the meantime, you have this financial life that's going on and nothing's being done with it because no one really has the authority to do those things. So it's really one of those things that when you meet with your estate planning attorney, that you should have that conversation of who are the people in your life and how, what are you most comfortable with?
And I just realized, if you don't mind standing over here, we've got the video going that way. And so I'm sure people would love to see the interaction as well. So there we go. Maintain our 6 feet apart. Okay. So incapacity. So 2 important documents there on that incapacity. So a couple of other important documents that we may want to think about is revocable trusts, irrevocable trusts. We'll touch on some of the benefits and drawbacks here. I have down there life estate. Now, trusts can get fairly complicated, and we could probably spend 3 hours on trusts and all of that, but there's Q-tips and there's CRUTs and there's CRATs and there's everything under the sun kind of a name. But essentially, I think I'm going to say this correctly, that basically most trusts fall under 2 types, either revocable or irrevocable. And as the name kind of implies, an irrevocable is that, in that once you do it, it's a done deal. And thankfully, we have an expert here that's going to tell us all about these. But so revocable and irrevocable trusts, and so primary differences between the both. And so, Alison, you want to kind of touch on those?
So the most common trust that I draft is the irrevocable living trust. And so basically it's irrevocable, just like it says. It's a grantor trust, which means that you are the person I'm writing it for is the grantor, and they are the trustee of the trust during their lifetimes. They can make changes to that trust at any point in their life that they still have capacity. Just like you would a will, people come and change their wills every year. You can change your trust every year. It's a very flexible document. The benefit of that is sometimes if it's fully funded and properly funded, it can avoid a lot of the probate process. If you don't fund it, that's okay, because you have a will that basically says everything I have goes into my trust, and then the trust distributes it. The other really attractive thing about the irrevocable living trust, or the revocable living trust, is that it is a private document. So in West Virginia, when someone passes away and they have a will, the will's taken to the courthouse and it gets recorded. And with technology today, people sit at home and they look up people's wills and they go, oh, Mr. Chikoriki gave this to that person, and I wonder why he only gave this much money to that person, and didn't, and they get all in your business. It's very important. Also, if you have minor children, nobody wants no parent, I think, wants the world to know how much money their child just inherited, because it's just ripe for people taking advantage of that minor child. So the beauty of that is you're distributing your assets through the trust. The trust is a private document. No one ever sees it unless you want them to. They only see the will, which says, I give everything I own to my trust.
So that was the revocable,
That's the revocable. Did I say revocable? I'm sorry.
revocable living trust.
That's
No, I
what
just wanted to clarify. Yeah,
But
yeah.
you said
Okay, sorry. That is a revocable living trust. An
First one there,
RLT.
revocable.
Yeah.
Yeah.
An irrevocable trust is, we don't use those a whole lot, and I'll tell you why. The most common use of them that we use in our office is if you're trying to protect a family farm and you want to leave it kind of as a legacy to your heirs, that they'll put the farm in the trust. Nobody can mess with it. And, family members can live there and work on the farm, and it gets really complicated, but they can protect the family farm that way, mostly from Medicaid. So, which is a long-term care planning sort of strategy. You have to be willing to part with whatever it is that you're putting in that trust. And by part with, I mean, you have absolutely no control over it. That's a really difficult thing for people to grasp. We do irrevocable trust also for Medicaid planning, which I kind of alluded to a little bit. If you have a large sum of money that you don't think you're going to need, and you project that you're not going to go into a nursing home for 5 years, and you want to qualify for Medicaid long-term care, which means you have $2,000 assets or less. So just wrap your head around that one for a minute. That's not a lot of money, but you feel confident that you're not going to need this sum of money. You can put it into an irrevocable trust and protect it as long as you don't go into a nursing home for 5 years after the point at which you put it in there. So it really takes some complicated planning. It's not something we do often, but in very kind of narrow situations, we can do those.
So I will say a lot of our clients, and it's something I know we all think about, but a lot of our clients are just scared to death, or maybe not scared to death is the proper word, but just, we've worked hard, saved. This is our retirement dollars, and I don't want to see it all go to a nursing home. And so that is a very, very common question we get. And a lot of people are like, well, I've heard about these trusts, and then they start hearing about the irrevocable, what it takes to do that, the steps they have to go through. And what do you mean I can't really, manage it anymore? Or, I don't have a good family situation. My kids find out I gave everything to this irrevocable trust. They're going to stick me in a home, or, so we do get a lot of questions around that. And so it does take some proper planning. And I think there's two sides to that coin, meaning that, essentially, and kind of what we're talking about is can I make myself poor enough to where I can now qualify for Medicaid, which is government assistance to help through nursing home. So, there's two sides to that coin. One, is it fair to put the burden of the healthcare costs on the rest of the community? Or should you use some, this is the reason why you've been saving and using it. And so there are two sides of that coin, but, that Medicaid planning, I think sometimes gets overused. In some cases, in the area in which we are, I think it can be used as a scare tactic and be used to really, force people into doing things that they probably shouldn't be doing. And so it is something that, a process, I think, that needs to begin early enough that you can do that planning while, you have all of your faculties. And, so I think it's something we really challenge our clients to really think about. What are the tools that are there? And then, as Alison had mentioned, you've got that look back, the rule that we have to consider. So if I use an irrevocable trust and I put all of my assets into it, and then I need nursing home care next year, there is that look back to where, even though it's in the irrevocable, it's possible that may end up having to come out, or or a portion of the size of those assets may end up having to come out. So definitely an important planning tool to think about. And like I would suggest, it's a great thing to begin thinking about early enough so that you can really kind of think through that whole process. I think too many times we start meeting with folks that are, getting to be a little bit on elderly side with whatever that may mean, but and not able to really kind of comprehend that or think through that, and the decisions, get more and more difficult to be made. So
Can I
Yeah, sure.
share a PSA about trusts though? So like Allison said, they're not with your will. They're not filed anywhere. So if you don't have it, you're SOL for a while. My mother-in-law had homes in a trust. Nobody had a copy of the trust. The lawyers were all dead. I ended up calling and talking to all these old people all over Maryland and found that one of the dead lawyer's wife still had a copy of the trust in his storage, in a box in storage. So we got it out. It's the house my sister-in-law lives in, who has special needs. It was pretty dicey. And you're SOL, so make sure that you share it with people.
Well, that's the moral of the story there. It's not the trust fault, it's the storage of the trust fault.
Right.
Down to
Yeah,
that.
and to make sure that.
that important
people know
documentation
that
of, and that's why I think whatever your organizational skill is, by all means, please, and we're all guilty of it, but, let folks know where your documents are, how to find them, if something happens. And so, it's a very difficult thing to sit down and do and talk about husbands and wives and families and things. So
Check with your parents now. Just in
yeah,
case.
absolutely. Good question to ask. So absolutely. Yes.
I just have a question. So you said the trust is private. So if my will, and unfortunately, I did have to record my will. So my will is public record now in Maryland. So if I change it and I put that everything goes to my trust, can anybody see that? Like, can anybody get a hold of my trust? So
Your trust is
I do
never
have stepchildren. Can their mother see what's in my trust?
No. And the only time that anyone should really request to see is if you're going to purchase something in the name of the trust, and take a loan to do that, your lender may want to know that the trust exists, but the certificate of trust should be sufficient for that.
Okay.
Or they may request to see the article which names the trust, that the trust exists and who the trustees are and the successor trustees are. They may want to see that portion of the trust, but there's really no legal reason for them to see the entirety of the trust and who's getting what.
Okay. So if we can just kind of address the life estate here briefly. So the kind of common question we get is, okay, so I may have protected my assets, but what do I do with my house? Right. So it's in my name. I've got a deed, or if it's in mine and my wife's name. So a life estate is a way to transfer that ownership. And so Allison, if you can kind of address that, it's primarily deals with the home, correct? That
Yes,
life
it's
estate
real
term,
property,
that life
yeah.
estate term.
Any real property. So life estates were basically designed under the law, which was, not to get too, I'm not going to get political about it, but the law was primarily drafted by men. And men typically owned most of the assets through history. And so they wanted to make sure that their land passed down to their sons, but they had a wife who was surviving. And what do we do with her? We don't want her to own the property, but we don't want to kick her out either. So they developed the life estate, which says, if my spouse survives me, she can live there for her lifetime. But at the moment of her death, the remainder owner is my son or whomever. So the life estate beneficiary, for lack of a better term, doesn't really have an ownership interest. They just have the right to live there for their lifetime. And the remainder beneficiary cannot kick them out unless they typically do something wrong, like damage the property or, there are conditions to that. In West Virginia, we have now, only since maybe 2010, the transfer on death deed, which is a much better option than the life estate. That primary purpose for the life estate, we've evolved as a people, and we don't really worry about that so much. We let women own property. It's crazy. But we didn't really use the life estate for what it was intended for originally. Now, you know, most people own their homes joint with right of survivorship, most married couples, or they own it as tenants in common. The tool that we have now in West Virginia is a transfer on death deed. And it's a beautiful thing, I think, because what can happen is I can say, I own my house, and my husband and I own it jointly. He deceases, and the house is solely mine. And I don't want this property to go through probate for a myriad of reasons. I want, you know, my will is going to say that everything gets divided equally among my kids, but I really want my daughter to get the house. Or, I mean, there are all kinds of reasons. It's a Medicaid planning tool as well, what we talked about before. It's kind of their first step of Medicaid planning. The transfer on death deed basically says, you know, upon my death, at the moment of my death, my house goes to my daughter. And it passes at my last breath, it passes to her. It gets recorded in the courthouse when you execute it. And it's there in perpetuity. However, the beauty of it is if you change your mind while you're living, obviously, you can't change your mind once you're dead, but if you change your mind at any point, you can revoke that transfer on death deed or change the beneficiary, so you can prevent the house or the real estate passing through the probate process by doing a transfer on death deed. And it's as simple as drafting a deed, naming the beneficiary and contingent beneficiaries if you want to, and recording it at the courthouse for 20 years. So it's a really good tool. Maryland does not allow the transfer on death deed.
So that's like the Maryland was a revocable trust. It was written just like the revocable trust was written just like that. She was married to, she was a widow and got remarried. So he was able to stay until at his pleasure.
Yeah,
Or whatever.
it's
it
the
was
life
called.
estate. Yeah.
Okay, so it's
And I'm
similar.
not 100% certain on Virginia. I don't think we have it either. But it is a beautiful tool that we have here in West Virginia, and I use it a lot for a myriad of different reasons. Maybe these other two states will step up and get it. But as of now, we're the only one in this region.
Okay, so maybe before we move on to this, there are a couple of points just kind of going through my head here that I can't remember if they're covered later, so let's just cover them now. And if we get to that, we'll rehash them or move on. But so the coordination of all of these things. So we kind of talked about some tools, talked about the will, talked about, so within that will, we need to think of a couple of things. Who's going to be the executor, which is going to act on behalf of the will? Executor, executrix. Is that the female version?
We kind of were getting away from that too.
So we're no longer sexist.
Typically, it's executor or personal representative.
Personal representative, right? So we're using that now. That's the 2023 version of. So, but within the will, there's an executor that is acting on behalf of the will. They're the person appointed to that. And so it's the coordination of all of these things that really helps to make these things, you know, work. So the executor then would help to. So do you want to talk a little bit about probate, just maybe at a super high level? So let's assume that's the only thing I have. So I pass, I have a will. So, you know, yeah, kind of what happens next, kind of talk about like probate, because sometimes that's people are like, oh, I don't want probate and I'll pay $4,000 to avoid probate, you know, when sometimes that may not be necessarily a bad thing. So probate is really just a court supervised process. So
Right, and it's for you Marylanders, it's going to be a little different for you too. But in West Virginia, probate is actually a fairly simple process as long as your ducks are in a row. We do not have probate court. You don't have to go in front of a judge at any time unless there is a dispute among beneficiaries or something like that. I think in DC it's called the orphans court. We don't have any of that. you basically, the executor or anyone really can take the will in and have it recorded. And the will says whoever your executor is, if it's not the executor who takes it in, they'll contact the executor, and the executor has to qualify. That's the first step. And so they have to meet some, guidelines for that. And then the executor has the job of marshaling the assets, finding out what the date of death values of all the accounts are, if there's real property, appraising the real property, getting the date of death value of everything, and memorializing that on forms given to you by the probate office called the appraisement and inventory of the estate. You file those, you have 60 days to file those. Then you file those and you have another 60 days of what's called a claims period, which it's out there. You see the notices in the newspaper that say the estate of so-and-so is now open. So you have 60 days to file a claim if the deceased person owed you money of any sort. If there are no claims, at that point, you can start making distributions as long as everything else is, all the other ducks are in a row, and start distributing. It can be a very simple process in West Virginia. If the estate is small, we just passed last year, the Small Estate Act. If it's under $50,000, you can do it by affidavit. If it's under $100,000 with real property, you can do it by affidavit. So that's even made it simpler for many West Virginians to probate the estate and get money that was owed to the recipient as well.
And so that probate process really, I think, if anything, kind of a key takeaway is it's not a scary thing and not something that you need to spend thousands of dollars to try and avoid. In some cases, if I have clients that have $60,000 investment account and they don't own a home, and that may be all they have. So in that case, do I really need a trust to pass that along? In some cases, we can put a beneficiary. So one of the key things I wanted to make sure we pointed out is a lot of people sometimes think that the will is going to take care of everything. But there's really one thing to realize is that your assets are going to pass by what they call an operation of law. So what we mean by that is how are things you own titled? So if I have a bank account in my name and my wife's name, that's a joint tenants, probably usually with rights of survivorship. I pass, it goes to my wife. So if I pass, I don't need my will to tell where that asset goes. It's jointly titled. It's going to go to my wife. So then if I've done a good job and I've put a transfer on death or payable on death on that checking account, I pass, goes to my wife passes, there's a beneficiary form that tells where that bank account is going to go. If it's going to go to my kids, it will bypass that probate process. It goes directly there. So there are some things that do pass through the will. So this TV is not labeled with a beneficiary. So there's no sticker on it that tells where it's going to go. That's where the will would kick in and say, maybe all of my assets get sold at auction and then all the kids, get to split the rest. So we need to think of things as operation of law. I have an IRA with a beneficiary. I have a 401k with a beneficiary. So that operation of law is something to think about and how that gets coordinated with your will. So just designate certain things in your mind. What's going to pass through my will? What can I pass outside of my will? And that really helps to pass that. It really helps that probate process. So hopefully you guys picked up on the trusts are things that, again, don't need to go through that probate process. I think I'm saying that correctly. If it's fully funded. So sometimes what I've seen happen is clients go to an attorney's office, they get all this stuff drafted, and they walk away and they think, wow, they stick their trust in the drawer and they never do anything else with it. So what Alison is talking about, when it's funding that trust, you need to call your financial advisor and say, hey, I just did my revocable living trust. I now need to change all of my accounts over to that revocable trust. And so that then is that's the kind of a funding, right? So we call it funding the trust, right? As Allison mentioned, there is a catch-all in your will that says if something gets missed, it's going to forward it to the trust, and I think I'm saying that would be subject to like a probate process or
Yeah, but it's very simple.
very simple way.
If I may, with regard to funding the trust, in your situation, you mentioned stepkids and, not wanting their bio mom to see that what they might or might not be getting. It's important in that situation to fund your trust, because when you die, if it's not in the trust, it gets recorded on the Form 601, which is a public document also. It gets recorded. So she would see, oh, she owned this, and she doesn't see who the beneficiaries of it are, but she sees she owned an investment account worth $300,000. If it's funded and once you have your trust and you put that investment account in the name of your trust, it now gets reported on the 602 at your death instead of the 601, and the 602 is a tax document and doesn't get recorded.
Okay.
So it stays private. So if privacy is your main objective, you want to make sure that your trust is funded.
Thank you.
And by
Okay.
funded, do you mean like the beneficiary on everything is the trust? Or is it?
No, well, it depends on the asset. So if it's an investment account that doesn't have a designated beneficiary, if it's just a regular account, she can go ahead and title the name of the account into the trust for Jane Doe established on this date. If it's something like an IRA that has a designated beneficiary, then you can name the trust as the designated beneficiary. It won't actually go into the trust until it needs to. Really, the only time you would do something like that, I mean, that's a personal situation. Typically, you try to have an individual as the designated beneficiary. But if there are circumstances like with minor children or a special needs person, you would want that to go through the trust.
So you can move money in and out of that trust.
Absolutely.
Yeah.
If it's a revocable living trust, yes.
Okay, so coordination of those documents. So know who your beneficiaries are, kind of know what your will says, know what your trust says, and make sure those things are coordinated. And so think of things that are going to pass by operation of law. Can we add things to help designate, the different levels of folks that are going to do that? So just try and make sure those documents are coordinated. And like I said, a lot of our clients kind of picture the will taking over everything, and that's not always the case. So your beneficiaries sometimes are going to go in different places. And so, in some cases, how does someone decide? We have one of our clients that has 18 grandchildren and great grandchildren. Well, it may be easier to just let that pass through the will. To say, okay, each one of my kids gets 2,000, great kids, grandkids get $2,000 each. Probably easier to specify that in the will and let that go. Or you're going to have just 6 pages of a beneficiary form. So if you come in and tell me you've got 18 great grandchildren you'd like to put on the beneficiary form, we smile and we take care of it for you. But so anyway, so just some things to kind of think about. Anything else you can think of kind of in the maybe how things are coordinated?
Yeah, I think when you go to your estate planning attorney, they're going to ask you a lot of questions about your assets, and they're not being nosy. They don't want to know how much money you have. It's primarily A, to see if you need any tax planning to reduce any tax liability, and B, because there are these buckets of money you can pull from, of maybe you want the 18 grandchildren to get 2,000. Well, that might make more sense to come from this bucket of money than it does from this bucket of money. And so in order to be able to help you with that overall planning, we really need to have a good picture of what all of your assets are, how they're titled, and who your current designated beneficiaries are. So we can help you plan like, well, it really makes more sense. You get a better tax advantage if you give this charitable organization from your IRA versus if you give it to them from your general fund. There are ways to go about that. The only other thing I would say is I see a lot of people, and you brought up TODs and PODs on accounts, especially with bank accounts. People say, oh, I just put my daughter on that account. It's fine. She'll handle it. Please don't do that, especially if you have more than one child. Because, and by I put them on there, I need to know, or your attorney is going to need to know, what do you mean by put them on there? Did you put them on there as a signatory? Did you put them on there as a joint owner? How did you put them on there? And I know BCT would never do this, but I have seen banks that when someone goes in and says, I want to add someone to my account, they automatically put them on there as an owner. So that the child's now in a car accident and gets sued, and they sue them for everything. And now mom's account's part of what they own. So mom's account goes away too. So it's just not a good idea. PODs and TODs are great, but not the joint ownership.
Yes, good point. Thank you for bringing that up. So,
Another question. I'm in transition between living down here and living in Maine. I talked to a lawyer in Maine about some legal things, and she said she could not do a will for me up there. I would have to do it down here. If I do a will down here and then transfer eventually to my living up there, do I have to have a lawyer redo the will, or what's the legal?
So most states have what's called full faith and credit, which means if your document was done here and it was done properly, it was properly witnessed under our state's laws, they would recognize it up there, and vice versa. I can't speak to Maine.
Yeah.
But that's how it works here. But if you know that's your final destination and you're likely to die in Maine, you should go ahead and get the will done.
She said she couldn't do it.
No, but I mean, if you're going to move from here and you move there and you're like, this is my forever home.
Yeah.
Get the will redone.
Oh, get it redone.
Yes.
So,
But if you're going to be here for 10 years, you should have a will done that's valid here in
Yeah.
West Virginia. But if you ultimately move there and you know then have it redone.
Okay.
You could even possibly get a codicil where it just says, now this is under the laws of Maine versus West Virginia.
thank you.
so, and what did you call that? There was a term,
Full faith and credit.
full faith and credit. So, okay. Living in multiple states. And I've even heard a lot of folks sometimes say, well, it's been 15 years since I've done my will. So what would cause someone to redo their will, Allison? So
Well-
does time really have something to do with it, or?
We suggest that people look at their wills, their estate planning documents every 3 to 5 years. And there are a couple of reasons for that. Families change, family situations change, babies are born, divorces happen, all kinds of things happen. So every 3 to 5 years, just take a look at it, see if it still meets your needs and what you want it to do. The other thing, particularly just in the past 2 years, 3 years now, is the law changes sometimes. And like the Secure Act that came out in 2019 has now changed twice. And, when I go, oh, geez. Like it makes my head spin, because documents I just did a year ago, really, I should contact those people and say, we just need to tweak your document a little bit because the law changed. If you don't check in every now and then and just assume everything is fine, it may actually not be. And it may be something your family has to deal with, once you've passed. So every 3 to 5 years is what we typically say.
Okay. All right. So we're coming on about 6:08 here. I've got about 15 more slides, but I am going to blow through these because I think there's a lot of fluff in some of them, but key things would be passwords. I would find a way to make sure you can pass along passwords. So that is getting something that's getting more and more important out there, is all these passwords that are out there. So, make sure we're organized. We kind of talked about that. Think about the people you love. Of course, I don't know how many more reasons we can help to give you guys to get out there and get something done. Contingencies, special circumstances. There may be some kind of special planning needs for maybe a special needs child, which again is probably a seminar in and of all of itself. I highly encourage you folks to work with a financial professional. So it is so important. You have a $200,000 in an investment account, and you don't want to spend the money to go get a will. We got to rethink that a little bit. So let loose a few of those dollars there. Thankfully, we can now pay you a little bit of interest on it, so you can earn a little bit on it. But highly encourage you guys to work with financial professionals. That's what we're here for. Some people feel like they got to get over a certain threshold before they can come in and talk, but highly encourage you to do that. Of course, work with our attorneys and specialties in that way. Sometimes it just may be a matter of, like those 5 special things, something to think about, that you may not have thought about before. So we kind of talked about the will, operation of law, how things pass, IRAs, those beneficiary accounts on there, kind of talked through all of those things. So, there may be some special planning cases, talked about those revocable trusts. Maybe there's a way you want to pay for some final expenses. There's some insurance types of trusts that you can have. And maybe one thing to kind of mention, a lot of folks don't realize that. So they think of life insurance as something that is going to be income tax free, and it is, but it does become a part of the estate. And I think I'm saying that. So if you have a $25 million life insurance policy, you have an estate tax problem. So if anybody have taken out a $25 million policy on your spouse, number one, we're very concerned, but you have an estate tax. So it is something to kind of take a look at. So start thinking about legacy planning with that. We're kind of talking here about, the what kind of a legacy do you want to leave? The next one here is monitor and update, which Alison kind of mentioned. So periodically, like I said, I've had clients come in and say, it's been 5 years since I've had my will done. Maybe I need to get it redone. And I'm like, has anything changed? Well, no, not really, but it's probably something to check in on. So things change, marriage, divorce, children coming in and out. You might want to change your mind about something. So is there somebody that you need to take out of the will? So something to think. All reasons why we may want to redo some things. But so working together is so important with that. One of the things we would suggest is kind of set a timeline for yourself. So give yourself some goals. So if you guys are goal oriented, think about, what your process is going to be, what your timeline is, kind of write those things down, and then kind of work towards that. So, we can help hold you accountable. So in our office, we fill out a client needs analysis. On there, it says, does the client have a will or not? So you meet with us next year. We're going to ask you again, do you have a will? And have you done that? Well, okay, we really need to do that. Remember, we talked about that last year. So, we can help hold you accountable in that regard. Also, working together with your advisor and your attorney is so helpful as well. So if you go get your legal documents done, and Alice can, say we meet her at lunch, she says, hey, I did, so-and-so today, get everything done, or, we can talk about clients and making sure we get that done together. So holding each other accountable and staying on track. And of course, it's going to make you feel really good when you get all this stuff done and everything's in place and you're ready to go and your legacy is all set. So you've found your trusted person who can handle the financial part. So you've talked about the person that can make the decision and do it in a nice way when that time comes. So who's going to pull the plug and who's going to manage your finances? So be thinking of those things. So it was kind of going through my mind. So before you go to meet with Alison, having in your mind who it is that's going to perform some of those functions. So is there a financial person? Is there more of a caregiver person? And think of those different aspects and who's going to do that. And believe me, it is not always a blessing. So if you have named your oldest child as your executor, you have not done them a favor. So doing those things is not a favor. So if youngest person says, why didn't you pick me as an executor? It is not an easy task and not always a favor. Okay.
Can you outsource that task to somebody other than? My
Yeah.
brother was the executor of my mom's estate. I don't want to give that to my kids. I'll outsource my money that's left.
The bank would be
Right.
happy to serve as the
Okay.
exec. We would want to review the documents first, just so you can tell us who's crazy, who we're gonna need to deal with. Just so we can make notes ahead of time.
Okay, so we talked about some resources here. So we have some resources that if you guys would like to have, so if you're interested in this, let us know. We'll write down your name and get your information from you. But getting organized, so we do have an organized and checklist binder, which we can help you maybe kind of think through some of those things. So legacy planning is not hard, so we just got to get started. So how do you eat an elephant? You eat him one bite at a time, right? So get started, get your will done, and start working on those documents. And so there we go. I think in 7 minutes we got through the rest of the slides. So,
So do we start first with Allison or do we start first with the bank? Like where do you get, how does the organization start working with you guys or working?
So I would say a lot of times, here's just one of the things. It's us as an advisor. These are normally things. Let's say you don't have any documents. A lot of times we're talking through some of the items that you may want to consider. Folks may not have heard terms of executor, executrix, or orphans court, or probate, or when would I need a revocable trust? When would I need an irrevocable trust? And I'm really scared about, maybe long-term care. So I'm not saying that we have to be the starting place, because really, Allison, obviously that's what she does day in and day out. But sometimes there are some things as you're meeting with your financial advisor, you may be able to ask some questions. And so I like to feel like once I've met with a client, they can go to an attorney and have thought through a lot of the questions she's going to ask. And it's not going to be, oh, well, I've never heard that term before. What is that? So if you go to meet with an attorney and you're kind of hit with, 10 unexpected questions, you might walk away and not be able to, you walk away and you've got to do a lot more planning. So in my mind, us as an advisor, if you met with us, we should have helped to kind of get you ready to go to see the attorney. And again, I'm not trying to replace her or them in any way. I just view my job as being able to kind of help prepare to meet with the attorney and to kind of talk through that. Yeah, very complimentary in every way. And I think that's also, what our trust and trust department and those folks do is, kind of talk you through some of those things. So by all means, if you start with the attorney, great. They're obviously going to get you on the, where you need to be. But I do view our role as helping clients think through terms, terminology, and kind of prepare you to. So, because a lot of times people are wrestling with, who do I really want to do this? So is it, which child am I going to bless with dealing with this stuff or things? So yeah, I don't know that there's any right or wrong answer. So you're going to get there, whatever. But any other questions?
Just generally, you talked about the tax ramifications of estate planning. I know IRAs have their own tax rules about how they're going to recoup that. Estates are generally taxable or not taxable?
And
Or is there a dollar limit?
It's the dollar limit. It's the over 11, I think it's 11.5-ish right now.
Okay.
For an individual, and you can port your exclusion to your spouse. So for couples, it could be almost 23 million. So in West Virginia, we really don't have many estates that have a taxable estate.
Surely.
Would be nice.
Yeah, there
Be nice
are
problem.
things, that are important. Other, when you say tax, there are lots of different kinds of taxes. For example, some people on their 401k at work don't ever list a designated beneficiary, and the default is it goes to the estate. Well, when it goes into the estate, it gets taxed at a much higher rate than it would if it went to an individual. If you named an individual, it gets taxed at their rate. So there are lots of different kinds of taxes and lots of different kinds of tax ramifications because of that. But, one of the reasons that it's important when you meet with your financial advisor to go ahead and get a financial statement. I love working with Leslie because she always sends her clients with a financial statement. And I'm like, look at this, it's all here. Is that we can look and see what are, where are the possible tax problems if there are going to be any.
So the question is like, so the estate, so when you pass and everything that's in your estate. So I think I'm going to say this correctly. When I die, everything I own is technically kind of considered within that estate. Right. So even though my IRA may have a beneficiary that's going somewhere, when I die, that technically is the value of my estate. So that estate. So I usually like clients. So the things that I say to clients is there's separate in your mind income tax and estate or inheritance tax. So when I die, my IRA probably has not been taxed. That's an income tax. So the estate tax that Alison is talking about is the inheritance tax, which is that $11 million kind of a threshold. But my IRA still has to be taxed in some way. And then there's ways in which we can dribble it out, slowly, all at once, or things along those lines. But so two things. So just because you've passed and you've got, a $5 million in your estate, that's not subject to that inheritance tax, but there may be other taxes that could come into
And the
play.
caveat, unless you're Maryland.
Unless you're Maryland.
It does have a state
Yes.
tax.
And Pennsylvania as well. So it is important to know what state you're in and what
Virginia.
so move to West Virginia. I think there's somebody say
My mother died in Pennsylvania.
Yeah.
West Virginia.
Yeah.
Pennsylvania
Um,
is a difficult state, and Maryland, and they're probably two of the most difficult states.
So both of our families from Maryland, one side's from Maryland, one from PA.
We drew the short straw on that one.
Okay. Any other questions we have? So you were introduced to the folks. You can find our information on our website. So by all means, feel free, shoot us your questions if you have any. And so those of you guys that joined us online, hopefully the audio and everything was good. And so we appreciate you guys joining us online tonight. And so with that, we'll end our presentation. Thank you guys all for coming. Appreciate your time. And yes, you're welcome.
Thank you all for coming.